Well, hello everyone, and welcome to Uncivil Law. As always, I am Uncivil Law. If you're enjoying our legal education content, please remember to subscribe. It helps our channel grow. For today's story is our continuing coverage of the Salts Brown story, because that's what this thing is. I feel at this point like I might owe an apology to everyone who is getting into law because of this case, because you're getting a very unfair view of what law looks like. Normally, law is very sort of dry and very dispassionate in a lot of ways, and it's very sort of, just very sort of formal. And it can be a good fight, but there's not a lot of this kind of stuff. This is, whatever this is a total nightmare. So I feel like everyone who's learning about this law from this case is getting a really bad picture of what law looks like, and that's unfortunate. But that being the case, we have what we have, and we'll go from there. So Michael Brown has filed a motion basically asking whether or not he can stay as a lawyer on the case. He wants to stay a lawyer on the case, so he's not asking to be removed. He thinks that Michael Brown, he thinks that Salts has this sword of Damocles over him, and that he is threatening Brown at any time, and so he wants that cleared up. Okay, so that's good. So we're going to read this stuff from Brown and try to figure out what all that is and see how that goes. So, and we're also trying out a new bot, which is supposed to hypothetically capture every question and every every sentence that starts with the word question or an at, so they can be put into one place, so I don't have to fight with the YouTube. So we're going to be playing with the bot for better or worse, so that's fun. We had to write it ourselves, so, All right, anyways, so here is the motion and sundry documents. Okay. On January the 13th of 2021, plaintiffs filed a declaration of a non-party witness, Laurie Ann Barnhart. In that declaration, Ms. Barnhart testified that on or about January the 10th of 2021, the undersigned offered to represent her as an attorney for the purposes of her response to a subpoena from the plaintiffs, suggested that attorney-client relationship was formed around that time, testified that she had some interest with regard to the lawsuit that was in conflict with the interests of the undersigned, defendant Ms. Paulson. Defendant was concerned that plaintiff include this testimony in the declaration to set up an argument to disqualify the undersigned and the firm from continuing to represent defendants in the matter. Okay, so Brown's concern is fair. This whole thing is crap, but, in so much as we're within the context of crap, it's fair. So within this milieu, it's fair. So Brown is concerned that this language was put in by Salts, which of course it was, because Salts prepared the declaration. Of course he did. Just as Brown prepared the declaration. Of course he did. It's Laurie Ann's ideas. It's Laurie Ann's concepts, but it's not strictly speaking Laurie Ann's words, because no lawyer would let a client or anyone else file a declaration just like themselves, because that would be insane. You take what they say and you put it in the best possible light. That's one of the things attorneys do. So, of course, Michael Salts wrote the declaration. That doesn't mean he did anything wrong any more than when Brown wrote the declaration, that Brown did something wrong. That's one of the things that attorneys do. And so Brown is concerned that Salts put this language in there because he was setting up a trap. So at some point in the future, Salts could say that you were representing Laurie Ann and move to disqualify him from representing Katie, which is not a wholly unreasonable concern. And he wants to clear that up. He's worried that Salts can say that he represented Laurie Ann, that there's a conflict of interest there, and as such, one of the things that should happen is Brown should not be able to continue in this case. That is a possible set of things that could occur. It's not necessary, but it is possible. So Brown is worried that at some point in the future, Saltz is going to attempt to use this to get him kicked off the case whenever it's to his strategic advantage. Okay. So, all right, fair enough. So that, makes sense. And I see the Uncivil bot did not capture Sassy George's Peach's question to me. Super great. The bot's not working. That's not a problem in any way. Accordingly, the undersigned arranged a meet and confer with plaintiff's counsel on January the 27th to discuss the matter and his plan to bring a motion to qualify, to request that this court enter an order finding that no disqualifying attorney-client relationship was formed with Lorianne. All right. To undersigned's surprise in that call, plaintiff's counsel assured the undersigned that, despite having included the above testimony in the declaration, they did not see a potential conflict issue. I didn't really either, to be honest. And had no intention of arguing for disqualification based on any such relationship. Yeah. Based on that representation, the undersigned sought further guidance on the ethics issue and determined that a motion to qualify could be obviated if plaintiff would simply confirm in writing what they represented during the meeting and confer, which is perfectly reasonable. Perfectly reasonable. Get it in writing. It doesn't have, just get it in writing. Can we just confirm what we said on the call? So I have this is just a fair representation of what we talked about. Good, always a good thing from an attorney. It's one of the things attorneys think about. It's like they have a call and they'll either write a summary themselves or they'll ask the other side to write a summary. So there's some written record of what was talked about. Very, very common. The memo for the file, just in case it ever needs to come up. So you have that memo to show that we discussed this and this is the representation, so you don't have to worry about, if it ever becomes an issue someday down the line, you don't have to ever worry about, well, he said this. No, that's not what I said, right? You don't have to worry about that. You contemporaneously record what was said, so you have a contemporaneous record. And so he'd like, ideally, Saltz to write this, because then it's coming from the person that would be in theoretical opposition to him. And so then it's not coming from him, so it's not self-serving, and it would be admissible, because it would be coming from a theoretical opposing party at some point in the future. So that's what he's trying to do. He's trying to get this contemporaneously written, and he's trying to get Saltz to put it in writing so that it will be useful for the purpose which it needs. It's the most ideal situation. Okay. The undersigned proceed to repeatedly ask plaintiff for the confirmation, but they refused. Initially, they explained that they wanted to reserve the right to move to disqualify if it becomes an issue later on, and if and when they learn more information. Maybe. The undersigned responded that the stipulation need only to repeat what they represented during the call, that they know current concerns that would cause them to ask for disqualification. Fair. And they could reserve the right to move in the extremely unlikely event they learn new information that give rise to a concern. Okay, so Saltz is like, if I learn more stuff, I might need to do something. And Brown's like, okay, well, you can reserve that and just give me what you know right now. Plaintiff then shifted their position, stating that they do not have current concerns about a current potential conflict based on what they knew at the time of the meeting and confer. Okay, apologize, I misread that. Plaintiffs then shifted their position, stating that they do have concerns currently about a potential conflict based on what they knew at the time of the meet and confer, and therefore would not sign the stipulation. Which is exactly one of the reasons you want to have this in writing, so you don't want to have any misunderstanding about what was said. Did Brown misunderstand what Saltz said? Maybe. Did he overread it? Maybe. But this is one of the reasons ideally you want it in writing, to avoid this exact problem. So, yeah. Defendants should not be forced to proceed under a constant threat that plaintiffs will choose some strategic time in the future to make this disqualification motion. They clearly hinted at the Barnhart Declaration. They're laying the groundwork at least, then clearly disclaimed on January 27th, then hidden once again when asked to commit that position in writing. Okay, fair enough. As such, the defendants asked this court to rule now on the disqualification issue, to give them some certainty that their defense in these proceedings, or future proceedings in another form, will not be disrupted by a motion to disqualify that they're keeping in their back pocket. Brown is a little bit paranoid here, but he's justifiably paranoid, so, fair enough. Well, I don't know if he's justifiably paranoid, because he always takes the most extreme version of it, but at least he has a reason to think this. So there's that. As explained in the dockets, the circumstances surrounding plaintiff's procurement of the testimony from Lorianne Barnhart was highly unusual and highly concerning, and there's reason to believe Miss Barnhart was not in a position to swear an oath to any testimony on the 13th. However, even taking her testimony regarding an alleged attorney-client relationship at face value, which we don't really need to because we have the email exchange, so we're able to form our own view of that. So we have objective evidence from which we could decide about attorney-client relationship. The undersigned remains qualified to continue to represent defendants for the following reasons. Okay. First, disqualification is a drastic measure, and the court must consider the danger of a motion to disqualify as a litigation tactic. Plaintiff's shifting position on this motion only underscores the concern here. Okay. Second, the emails on which the declaration relies do not support a reasonable belief on the part of Ms. Barnhart that the undersigned out for act as attorney. Well, I disagree with that. I mean, we can kind of have an agreement about the ultimate conclusion, and we can also have an agreement about Lorianne's subjective belief, or what her subjective belief would be. But to say that there's no evidence from which she could form a subjective belief seems a little bit much. Because he is an attorney and was acting in concert with her to help prepare some things, and so she might have perceived it. And that might be a reasonable perception. Now it might not be true in reality, and there's a whole bunch of reasons why that might be true, but I don't think to say it's baseless would be completely fair. Which is also one of the reasons, incidentally, why you as an attorney, if you're in the situation, want to be careful, because you don't wind up in these troubles if someone thinks that you're their attorney when you're not. So that can be a real concern, and attorneys need to watch out for that. If someone is calling you for help with a specific thing, right, and you know it's a specific thing, so they're contacting you, you're a lawyer, and they're not asking like a general question. They're asking a very specific question. I've received this indication they want my stuff. What should I do? That sounds suspiciously like the role of a counselor. So if you're not doing that, you want to make that really clear, that you're not giving individualized advice, right? So if someone is calling you and say, I have a problem, like, okay, that's specific. Now I'm answering your specific question. Now you might think I represent you, right? So you have to watch out for that. Third, even the emails could reasonably be construed as an offer of representation. Ms. Barnhart's own testimony establishes that she rejected the putative offer. I don't know that that's necessarily true either. She might have changed her mind. Indeed, she testified that she is suspicious and not comfortable with the undersigned acting as attorney. Therefore, she cut off all communications. Yeah, but that could have happened out later. So, okay. Fourth, even assuming an attorney-client relationship was formed, Ms. Barnhart does not have any identifiable interest with respect to the lawsuit. She doesn't, that's true. This lawsuit will not impact her one way or another. There's no possible scenario in this case that could impact Lorianne. That's true. So she doesn't have an interest, let alone any interest that might be prejudiced by the undersigned continuing to act as defendant. Fair. Indeed, she herself expressly and repeatedly recognized her only connection is a fact witness, with information that's relevant, if at all, to the only issue of this court's personal jurisdiction over defendant. Presumably. Fifth, any confidentiality would have attached to Miss Barnhart's communication with the undersigned was waived by virtue of declarations, express reliance on, and characterization of those communications for the purpose of impugning. Yeah, well, that's kind of neither here nor there. The privilege of the communications being waived is kind of off point. So I think that they were because of the relative rules, but yes. Okay. Ms. Barnhart initially made contact with the undersigned email on December the 24th. She explained that she understood the undersigned was Miss Paulson's attorney and expressed concerns about being harassed by plaintiff's counsel and abusively outed in a Fulmer declaration, in which they exposed irrelevant but very damaging personal information about her. I don't know about that, but okay. The undersigned responded to Miss Barnhart as a potential witness, not a potential client. But you didn't make that exceptionally clear if that's true. And began a series of email exchanges and 2 telephone calls over the subsequent 18 days. The majority of the email conversation centered on Miss Barnhart's agreement to sign a declaration for the first... Yeah, the bot is not working. The bot is just simply not working. Yeah. Sorry, we're trying to figure out how to make this bot work and it's not working. The undersigned responded to them as a witness. The majority of the email conversation centered on Miss Barnhart's agreement to sign the declaration, which would be filed by defendants. The purpose of the first Barnhart declaration was twofold: to explain the abusiveness of the Fulmer declaration, and specifically Miss Fulmer's belief that she was deliberately outed in retaliation over a spat she had with the counsel, Michael Saltz, in November of 2020, and to confirm defendant's statement that they did not know Miss Barnhart resided in Washington until the fact was discovered in the lawsuit. Miss Barnhart helped to prepare and edit the declaration and was eager to sign it before the undersigned informed her there was a delay. That does seem to be correct from the record, yes. The undersigned and Miss Barnhart also exchanged emails and spoke about plaintiff's subpoena to Barnhart, which was never served. It is the emails regarding the latter subject that form the basis for the suggestion in Miss Barnhart's declaration that she and the undersigned formed an attorney-client relationship, which maybe they did, and her perception of which might be right. It's not completely outside the bounds of existence, not for at least the reasons that Brown did not make this particularly clear, which being an attorney for as long as he is should have probably done better. Yeah. The undersigned and Miss Barnhart spoke on the phone on January the 5th about the declaration subpoena. The undersigned explained that he was defendant's attorney and not hers, which he could have put in writing. The very same reason that he wants an email from Saltz, right, to make sure that the understanding is clear on a written record, is the very same reason this should have been in writing. Now, in this case, it would be coming from him to her, which is effective for the purpose it needs to be, because the purpose of it is to inform her that she is not the client, right? So she doesn't need to understand that or agree to that. He just needs to make it clear that that's what's being communicated. So an email from him for this purpose would have been perfectly fine. So in the same way that he wants a letter for the file from Saltz, he should want a letter from the file for himself. And he didn't do that, and so that's bad. And now we're in this position of what exactly did he say and didn't we say? We're in the exact same position that Brown doesn't want to be with respect to this communication with Saltz. So maybe once burned, twice shy, I don't know. But there's something there. Miss Barnhart now relies on emails the undersigned sent subsequent to the call, suggests at some point he became her lawyer for responding to subpoena, which is reasonable because she has receipts and you don't, because you kind of screwed up that one. In those emails, the undersigned provided general information and admonitions to Barnhart regarding responding to subpoenas. Okay, this doesn't really work. You can't really do this. You can't really frame this as generalized legal advice when you're talking to a specific person. If you know that you're talking to someone about a specific issue they specifically have, you can't really just give out generic legal advice. Or it would have to be they basically like contact a lawyer in your area or something like that. But yeah, you'd have to make that very, very clear. So yeah, this doesn't really quite work. So Brown should have been a little bit more cautious here. It's a little bit hard to say this is just generalized information when you have a specific call from a specific person worried about a specific thing. And you're like, this is just generalized information, not specific to you. Do they perceive it that way? This is where you run into potential problems. Now, maybe all this is okay. Maybe Brown's in the right. So maybe he's right in the end, but you could avoid problems with a little bit more care. The emails pertaining to the subject, among other topics, can be found in the docket. Yeah, we saw those at length. Ms. Barnhart's emails to the undersigned late on January 10th and continuing into January 11th began to sound confusing and appeared to reflect an increasing level of anxiety and even despair over harassment and intimidation. That's a reasonable characterization of those emails. We've read them. On January 12th, after 18 days of frequent communication with the undersigned, fair, Ms. Barnhart flipped and contacted plaintiff's counsel. That is also true. The next day, plaintiff's counsel interviewed Ms. Barnhart for 11 hours. That seems to be true. Prepared a different declaration for her to sign, and procured her sworn signature to it. They did this with the knowledge that Ms. Barnhart believed she's represented by the undersigned. Okay, that doesn't even begin to work. Because the client can change their mind about who represents them. Now, Saltz, of course, wants to be clear about that. She's not a party to this case. She's not. But if someone comes to you and says, I don't have a lawyer, I'm looking for a lawyer. If they say that to you, you can rely on that. If they say it to you, you can rely on it. And it's like, okay, because the client can always get a different lawyer. So just because you're represented by a lawyer doesn't mean that you can't go shopping for other lawyers. And then your lawyer contacts me and says, you're fired, send us the case file. And I say, okay. That's the way that's supposed to work. So even if Saltz knew for an absolute fact that Brown was representing Lorianne, if Lorianne says, I don't want to be represented anymore, I'm looking for help, Saltz can be like, okay. That should be, especially because she's not a party to the case. If it were Katie, then you'd be a lot more cautious. So if Katie suddenly walked up to the door to Saltz and said, I don't want to be represented anymore, I want help. First of all, there's a massive conflict of interest problem, but even putting that aside, with a massive conflict of interest problem, you'd still be really, really cautious. But yeah. She's eager to swear an oath a week earlier to an entirely different and nearly perfect contradictory version of events. I don't know about perfectly contradictory, but it was definitely different. The 150 emails exchanged between the undersigned and Miss Barnhart over the previous 18 days were perfectly consistent with the declaration. I'll agree to that. I didn't sense any conflict between the emails and the declaration. That much seems true. Which she was eager to sign and contradicted her testimony that they're putting in front of the second Barnhart declaration. She admitted to being confused and unable to remember things well because of medication and anxiety. That seems to be correct. After the second Barnhart declaration was filed, the undersigned came to possession of information strongly suggesting that Miss Barnhart was not aware of what she's signing when she signed it. Which maybe that's true. She does seem to be a suspect witness. I think her value as a witness has gone to zero, particularly for our current purposes. So if I were assuming that I was trying to consider this in the first place, which I don't know that I would be, because nothing about this agency stuff I don't remember was brought up in the initial complaint. It's been a long time since we read the initial complaint, so we have to go back in our minds. But I don't believe that there was anything in the initial complaint about Lorianne being an agent. Specifically Lorianne, or specifically an agent. I don't remember this agency theory being in the original complaint. What I do remember being in the original complaint is that Katie has a lot of subscribers and she has people give her super chats from Washington. She has viewers from Washington. She has subscribers from Washington. She gets super chats from Washington. This I remember. I do not remember anything about the agency theory in the original complaint, which was so long ago. So this all stuff is late addition, which means as a judge, I have to take what's in the complaint as true. I have to take what's in the complaint as true. I don't have to pay attention as a judge to any of this periphery stuff. So first of all, I wouldn't, unless there is something about agency in the original complaint, which I don't remember, which I really don't remember that being, but unless there's something about agency in the original complaint, I don't have to consider any of this because none of it matters. I have to take what's in the complaint as true, what's well pled. And all this is not well pled. All this is a lot of bullshit. So, So as a judge, if I'm the judge in this case, Lorianne is irrelevant. She's irrelevant. I look at the complaint, and I look at the motion to dismiss and the responses, and I take everything in the complaint as true. Right? Everything in the complaint or its attachments as true. If there's a disputed fact. I don't believe Lorianne comes into that analysis in any way. So it doesn't, to quote me, it doesn't matter. It doesn't matter. No one cares. No one cares about Lorianne. I think Lorianne is a complete red herring. I did bump up the odds because of Lorianne from 60 to 65. Because I could see the judge disagreeing with everything I just said. Right? So I have to calculate the probability the judge will disagree with literally all the things I just told you, which is not exactly outside the realm of possibility. I think I obviously have the better end of that, but I'm within my own head, so I can't get outside my own biases. So I did bump it up from 60 to 65% on the off chance that the judge somehow disagrees with me and really goes whole hog into the agency theory and writes an entire opinion around agency. So in the off chance that the judge goes down that road, I'm like, okay, that's worth a 5% bump. So we'll go from 60 to 65%. But personally for me, it doesn't matter. No one cares. It doesn't matter. No one cares. Which I've been saying for quite a long time now. No one cares. Again, I feel like I have some sort of obligation to apologize to you, everyone, if this is your first legal case you're being exposed to. Because you're getting a very skewed view of what law looks like. This is not what normal law looks like. This is some other crap. And so, just saying. I'm sorry that if this is your first exposure to law, I'm really, really sorry. I'm really, really sorry. I feel like my entire profession and entire practice is being badly misrepresented. I'm so sorry. In the second declaration, Miss Barnhart states the undersigned became her attorney at some point with respect to subpoena. Circumstances surrounding the preparation of the declaration, Miss Barnhart's state of mind when she signed it. However, taking even as a value, the undersigned is not disqualified. Okay, that's good. This qualification counsel is a drastic measure that should be imposed only when necessary. The court must consider the danger of a motion to disqualify as a litigation tactic. Here are the circumstances surrounding procurement of the second Barnhart declaration, and plaintiff's shifting position should only heighten the court's suspicion of their motives. You know what it heightens my suspicion of? If I'm the court, it heightens my suspicion that I don't care. My suspicion is I don't care. This heightens that suspicion. I'm not required to care. In fact, there's a pretty good case I literally legally shouldn't care. Not only do I not care, I legally shouldn't care. Because none of this matters. This is all completely devoid. It's like, oh my God. Why can't we stay focused on the issue? Why can't we just stay focused on the issue? One issue at a time, guys. This is the way law normally works. We do one issue at a time, one thing at a time. Right? We stay within the world of that thing. Did any of you ever see the Mask of Zorro with Antonio Banderas? And where the old Zorro, who did that? I can't quite remember in the old role. But where he said, we're going to start with the Master's Circle, right? And we're going to teach you about the Master's Circle. And there is no reality outside the Master's Circle. The Master's Circle is your entire world. And Antonio Banderas says, my revenge. And the Master says, nothing exists outside the circle until I tell you it exists. The person that you want revenge against does not exist until I tell you he exists. That's a pretty good analogy. That's how I feel like that. So this is the point. This is the point of the this is Anthony Hopkins. That's right. Anthony Hopkins. That's right. Thank you. So this is the point where Anthony Hopkins goes to Antonio Banderas and says, this is the Master's Circle. Here is the universe. Here are all the things that matter. And then people, and including up to and including the attorneys are like, how about this tea? How about this? How about these meanness? How about all the things that they've done outside that? And this is where I, as the Anthony Hopkins in this scenario, say nothing exists except this circle. This is your entire world. There is no reality outside this circle. This is all that there is. Nothing more until I tell you otherwise. So that's a pretty good analogy, actually. We need to get a master circle out here and make them start running laps through it or something. The issue is personal jurisdiction, nothing more. There is no reality beyond that. Well, they said this in this affidavit. They said this in this affidavit. They did this. They did this. Nothing exists. There is only personal jurisdiction. Can we go back to that? That'd be great. And then once we're done with that, we can go to the next issue with the circle and the next issue with the circle and so forth and so on until we've dealt with all the issues. But apparently we're under a desperate attempt over here to say that there are things in reality that exist outside the circle. And I'm desperate saying there's no reality outside the circle. It's me and Anthony Hopkins over here trying to hold the fort. It's not going great. An attorney-client relationship is deemed to exist if the conduct between an individual and an attorney is such that the individually, subjectively believes the relationship exists. You know, fair enough. Okay. However, the belief of the putative client will only control if it's reasonable, formed on the attendant circumstances, including attorney's words or actions. The determination of whether attorney-client relationship exists is a question of fact. The burden of proving the existence of attorney-client relationship falls on the party asserting it. Okay, I'll take your word that that is the correct case law. As explained below, the facts do not support the finding that Ms. Barnhart and the undersigned entered into an attorney-client relationship. Indeed, Ms. Barnhart's own testimony demonstrates that no such relationship is formed. Okay, let's try to figure out that now. So now let's move into a different circle of was there an attorney-client relationship, which I don't know why we're in the circle, really, because it only matters if there's an attorney-client relationship if it matters that Laurie Ann exists, which since it was never brought up in the original complaint, it doesn't matter. Laurie Ann doesn't exist. She is not within the circle of personal jurisdiction. But we're going to pretend that she's existing for some reason. I don't really know. There is no Laurie Ann. That should be where we are. The suggested attorney-client relationship was formed as premised on two particular emails. One on January 10th and another on the 11th. Neither of them, taken alone or along with other emails pertaining to the subpoena, support a conclusion that the undersigned was acting as an attorney with respect to the subpoena. Ms. Barnhart wrote to the undersigned on the 8th, explaining that plaintiff's counsel's harassing conduct had already caused severe anxiety and she may just ignore the subpoena altogether. The undersigned attempted to respond in a manner that would calm Ms. Barnhart's fear and dissuade her from simply ignoring the subpoena. This is what led the undersigned on the 10th to write sentences on which Ms. Barnhart now relies. I recommend you sit tight, accept service if they come to your door, and then we can take it from there. You're not in any trouble. Which, maybe that's legal advice, I guess. In her declaration, Ms. Barnhart states, such statement confirmed to me that I apparently was the client of Mr. Brown, and that I understood his statement to mean that he was inserting himself into my situation of having to respond to a subpoena. It's difficult to know what it means to say something that confirms something that was apparently the case. No, it's not. That doesn't strike me as hard. Can you have something that confirms something that's apparently true? Yes. Something apparently was true. This was confirmation it was true. That's not really that weird. Your hands smell like gasoline. Apparently you went to the gas station. There's now more fuel in the car than there was before. That would be confirmation you went to the gas station. I don't know, but the idea of confirming something that appears to be true doesn't strike me as that weird. It might appear to you that I'm frustrated. I'm frustrated would be further confirmation that that was an accurate perception. The question of whether Miss Barnhart subjectively believed the undersigned was her attorney, not whether it was apparent that the case the undersigned was. What? Further, even if it was read to assert such a subjective belief, the belief must be reasonably formed on tenet circumstances, including attorney's words or actions. Ms. Barnhart explained the undersigned's email apparently confirmed an attorney-client relationship because she understood the statement to mean that he was inserting himself. Yeah. Basically. To the extent any meaning can be reliably discerned from that odd phrase, it's not a fact or a circumstance from which a person could plausibly conclude there's an attorney-client relationship had been formed. Yes, they could. Which is one of the reasons that you wanted to be clear. At any point would have been helpful. There was one email where you could kind of get there, but you could have been a lot clearer. So, Miss Barnhart's subjective belief that you were acting as her attorney is not really ridiculous. Now, I don't really think there was a problem in that, incidentally. I don't think there was a problem because I don't think there was any conflict between Lorianne and Katie Joy at the time Brown was acting. So I don't think Brown did anything wrong as an attorney. So I could conclude that he was the attorney and also conclude he didn't do anything wrong because I don't really think he did. So because there was no conflict between Katie Joy and Lorianne at the time Brown was doing stuff. At the time Brown was doing stuff, everything Lorianne said was completely compatible with everything Katie said. There was no conflict of interest. And Lorianne wrote this 2,000-word missive about here's the reality of what happened. And that reality was completely consistent with what Katie Joy was saying at that time. And so, seemed okay. I don't think it was a problem. Personal opinion, but I don't think there was a conflict of interest. There was no apparent conflict of interest at the time. Either way, though, he should have been clearer about what he was doing. Whether he's an attorney or not, he should have been clearer either way. So I don't think it's bad if he was, but he definitely wasn't making it clear either way, which leads to this kind of thing. Because now he has to try to figure out what was and was not true when it could have been clearer up front. So, The second email from the undersigned on which Barnhart relies is dated January the 11th, 2021. That email was a direct response to Barnhart emailing the undersigned the following message regarding the subpoena. I'm not going to court. I have no money. I don't know how to download everything on my phone, so it won't be done. The undersigned responded shortly thereafter. The portion of the response in which the declaration relies states as following. You don't need to spend money or hire a lawyer to respond to the subpoena or file a declaration. I'd like to stand up for you by filing a declaration if you'd let me. It costs you nothing. Could a reasonable person perceive I'd like to stand up for you as saying I want to be your attorney? I think so. If that wasn't true, he should have been clearer. Also, I don't think it was a problem if he was. But this was not handled with the greatest care either way. So could Lorianne perceive it that she was a client? Seems reasonable to me. Seems reasonable to me. Ms. Barnhart characterized this as an offer to represent me at no charge. However, in this context, it's clearly not an offer to represent a lawyer for free. Really? In this context, it's clearly not? Okay, convince me it's clearly not. The undersigned intent in writing these sentences in response to Barnhart's concerns was to reassure her of two things. First, the undersigned wanted Miss Barnhart to understand she did not need to spend money to respond to the subpoena, for example, by paying to have data retrieved, because she did not know how to do it. What? Offering to provide general information to a witness regarding logistics of gathering information from a smartphone is not the sort of assistance that constitutes legal advice or supports a witness's subjective belief an attorney-client relationship has been formed. Why is it every time Brown talks, I'm more and more convinced that Lorianne was in fact his client? Why is it every time Brown opens his lips now, I'm even more and more convinced that Lorianne. So I was like, I'm not sure she was. Why is it every time that Brown opens his mouth, I'm increasingly convinced Lorianne was his client? It was apparently true that Lorianne was his client. Now, because he opens his mouth, it has confirmed that impression. It has confirmed that which was previously only apparent, that which was previously only in doubt. See how that worked? See how that worked? There were things that I was not sure about, things in which I was doubt, things which there was only apparent truth of. And now, because he keeps talking, it has confirmed the apparent truth. See how that worked? We moved from apparent to confirmed. Amazing. Deep. Wow. Second, the undersigned warned Barnhart to understand that based on what she told me, she did not need to represent a lawyer representing at all in response to pleadings. Yeah. After describing the above email passages as forming an offer to represent her, Ms. Barnhart testified that she in fact rejected the offer. She explained that she was suspicious of the motives in offering to assist with the subpoena response. She is not comfortable with Brown having control of the production. She did not feel comfortable with Brown's offer of representation. She was concerned there'd be a conflict of interest. Indeed, Barnhart testified that she was so uncomfortable with the offer she responded to it by cutting off all communication. No, that's not quite the timeline of what happened. That's not quite the timeline, no. And in fact, Miss Barnhart did cease communicating with the undersigned. Okay. I think I'm sold on the concept that there was an attorney-client relationship at this point between Brown and Lorianne. I think I'm sold on that at this point, for whatever it's worth. Because I don't know that Lorianne matters or cares or exists, as we discussed before. Ms. Barnhart's suggestion of the formation of an attorney-client relationship potentially implicates potentially implicates Rule 1.9. This rule provides that a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives interest in writing. She has no interests that are materially adverse. I think that's probably true. First, the only indication of adverse interest is in the form of vague assertions in the declaration. As set forth in detail, that declaration lacks evidentiary value because of circumstances surrounding its drafting. Second, the only interest even hinted at in the declaration is the alleged possession of information that contradicted testimony. As explained in length, that information is contradicted by what Barnhart said and wrote to the underside over an 18-day period. Ms. Barnhart's first story was plainly consistent with defendant's interests. It was plainly consistent. Yes, I completely agree. Her first story was completely consistent. I agree. It'd be unfair to defendants and undersigned to permit plaintiffs to create a disqualifying by citing changes in the story. I agree completely. I agree with this completely. This is right. This is right. So, see, I can agree with Brown and disagree with Brown. It's amazing when you're trying to be reasonably objective and reasonably fair to every side, right? You can criticize on one hand and you can agree on the other matter. You call every issue like you see it. See, you don't have to be ride or die. It's possible. You don't have to be ride or die for any of these people. You can actually try to analyze things in a fair way and say Brown is completely off base here, and then turn right around and say, okay, Brown's right here. But, some people seem to find this difficult to believe or something, because it's like, are you a shill for Katie? It's like, I just got through criticizing Brown, who is Katie's lawyer, for some length of time, saying that I don't buy any of this. This doesn't make any sense. And now I'm going to turn around and agree with Brown, because I think he's right. Ooh, wow. Third, even if Barnhart was in possession of information that somehow be damaging, he would not give her a material interest that could be jeopardized by the undersigned continue to represent defendant in this matter. Indeed, Ms. Barnhart repeatedly told the undersigned that she had no position with respect to claims in litigation. She's caught in the middle. Nor could she really have a claim or a position, nor would her position matter. Ms. Barnhart's opinion as to this is valueless. As so is mine, for that matter. I'm not involved in the case. I'm giving you a legal opinion. But technically, my opinion is of no material value, because I'm neither the attorneys nor the judge in this case. But I'll give you my opinion for whatever it's worth. But yeah, I also have no material interest in this case. Correct. It doesn't influence me one way or another. There's no set of circumstances that could influence me. Right. So I also have no position. Ultimately, at the end of the day, I can give you a position what I think is real, but at the end of the day, it doesn't matter to me one way or another. Moreover, to the extent Miss Barnhart actually had such damaging information and had an interest in disclosing it, she's already done that when she gave plaintiff's counsel access to her email and social media accounts, allowing them to review everything therein, apparently with no constraints. How do you know that they gave access to the email and social media accounts exactly? Oh, okay. I think that's a bit of an assumption there. Ms. Barnhart clearly waived any confidentiality with respect to her communications with the undersigned. Ms. Barnhart's assertions relating to attorney-client relationship also potentially implicate Rule 1.9. Rule 1.9 says a lawyer who formally represented a client in a matter shall not thereafter use information relating to the representation to the disadvantage of the former client, except as the rules would permit with respect to a client, or where the information has become generally known, or reveal information relating to the representation except as would be permitted. The key concern behind Rule 1.9 is that confidential factual information, as would normally be obtained, that would materially advance the client's permission. There's no risk of that here. There isn't. That's true. Assuming for the sake of argument that Barnhart had a reasonable expectation of attorney-client confidentiality during her discussion, she clearly waived it by expressly relying on those very communications in her declaration. Yeah, that's true. And doing so for the purpose of impugning professional integrity. Correct. We've read the rules on that. It's also Rule 4.2 if memory serves correctly. Further, to the extent the information provides undersigned's benefit, it's not implicated because the information no way harms the interest of Miss Barnhart. Correct. For the foregoing reasons, defendant respects this court's order, finding no grounds to disqualify. Okay, I find no grounds to disqualify. So, assuming that I care about any of this, which I really don't. So, technically speaking, to me, the whole thing is moot. But, assuming we care, I agree with this. But, I really don't. Okay. So, then we have the proposed order. They came before the court. Hereby orders that the motion is granted. Okay, great. That's fine. Whatever. So now we have a declaration from Michael Brown. I'm a lawyer. We spoke on the phone about the 5th, about the declaration. We already read all this. Why am I reading it again? I don't know. I like pain. In January 11th email, I wrote, you don't need to spend money or hire a lawyer. I'd like to stand up for you. My intent in writing these sentences to respond to the concerns was not to offer to represent. I'd like to stand up for you by filing your declaration is not an offer to represent. Let's just back up one step and really read this and appreciate this. I'd like to stand up for you by filing your declaration if you let me. This is not an offer to represent her as an attorney. I'm sorry, Michael. I'm sorry, Brown. I don't buy that at all. I don't buy that from the subjective position of Lorianne. No, I don't buy that. I don't buy that at all. No. Just no. All the no. All the no. No. Rather, it was to reassure her she did not need to spend money. Based on what she told me, she didn't need to be represented by a lawyer. Well, she doesn't, strictly speaking, need to, I suppose, but if she wants one, there's that too. After the second declaration was filed, I was concerned that plaintiff was setting up an argument for disqualification. Accordingly, I arranged a meet and confer to discuss the matter. To my surprise and temporary relief, plaintiff's counsel assured me they had no intention of arguing disqualification. Based on that, I sought further guidance on potential conflict issue, and determining this motion to qualify could be obviated if it can be confirmed in writing. Sounds like he called the ethics hotline, which is always a good place to start. I proceeded to repeatedly ask plaintiffs for confirmation, but they repeatedly refused. Initially, they explained they wanted to keep open the possibility of moving to disqualify if they learned new additional information. I responded by explaining I only need a stipulation based on what's currently known. Then their explanation shifted. They responded that they did have concerns based on what they knew, and therefore would not sign the stipulation even with further information. And I declare under the penalty of perjury this is true. Okay, fine. That's fine. I believe you. I believe you as to the facts. I don't believe you as to your conclusions. Well, I guess I don't believe you is wrong because it's not a statement of fact in which I can believe. I don't agree with you. That's better. I strictly speaking can't believe that, I just don't agree. Anyways, all right. So from Michael Brown, I looked further into the matter of disqualification since you informed me last week that you have no interest in challenging my ability to continue based on Lorian's statement. So he's doing exactly what I would do in this situation. He's doing exactly what I would do, right? This is the memo for the file. This is a good thing to do. This is a good practice. This is a good practice, just generally across the board. This is good practice. So if you have a conversation with someone and it's important in some way or might be important in some way, document it. Document it immediately, preferably by sending them an email with it. And then you can say things like, please let me know if this is any way wrong. So you have some contemporaneous written documentation. The memo for the file is a very good idea in general. If it's important, make a written record. Send it to the other person. Ask them if there's any correction. Ideally, you get a response back of any variety. Any response would be great, including this looks fine would be great. And if you get a correction, that's also fine because now you have a corrected record. So the memo for the file is a true tactic and, good job. Good job. I believe that under the circumstances, the motion to qualify can be obviated by a stipulation regarding the... I'd like to proceed. I'm attaching a draft stipulation. Please let me know if you're willing to stipulate. Okay. I mean, he might have screwed up other stuff, but, he's doing this part right. Hi, Michael. I don't believe there's anything to stipulate to in this instance. Even if we did stipulate to such a motion, I don't believe we should be precluded from raising the issue if one becomes an issue later on. I've never been asked to stipulate to someone being qualified to represent a party, so I'm not sure that's necessary in this instance. This is coming from Jeffrey Bianco, one of his co-counsel. Okay. Let me provide for more context why I think I need the motion to qualify or get a stipulation. You prepared a declaration for Lori in which she appears to say she believes I was her lawyer. You claim that when she said that to you, you made contact with her around January 12th. You also sent her a declaration that she had some interest in conflict with Katie's interest. By putting in that declaration, you were suggesting, I would phrase this a little bit more cautiously, rather than you were suggesting. This is aggressive. This is Michael. Okay. If Michael Brown has one fault as an attorney, is that his language is overly aggressive when it doesn't have to be. And he's putting people into corners, and he needs to work on that. He takes the worst possible interpretation of reality, and he also makes very charged language with you were suggesting. That's putting words in the other person's mouth. Better would be it could be read to suggest. Not you were suggesting. You don't want to do that because now you're putting in a position of someone where they might have a fight or flight response, right? So they're putting someone in a position where they're going to fight with you. No, that isn't true. And now you're setting up tension. So if Michael Brown has one fault as an attorney, which we've seen time and time again, among other faults, is that he's overly aggressive when he doesn't have to be. He always is overly dramatic. He quite often takes the most negative interpretation possible. He quite often takes aggressive language to the other attorney. He quite often acts in an antagonistic way with the other attorney. We've seen this over and over again. And so if Michael, if you're out there and you're listening to me, I'm trying to help. I really am. For whatever value it has, I'm trying to help you, man. I'm just trying to help you a little bit because this is too much. Michael, I don't know why you keep doing this. Please, don't. It's not necessary. Okay? The clients can be fighting each other as much as they want, right? And you can fight the other side in the legal documents, but you don't need to make this personal with the other attorney. It's completely unnecessary. And it's not helpful to anything. Having a good relationship with the other side's counsel can often be quite helpful to a number of issues, even if the clients are in a bitter disagreement. See, that's the key. The clients are in a bitter disagreement. You don't have to be in a bitter disagreement. That's fine. It's okay to not have to make this personal. You can be professional. You can be professionally detached, and you can zealously fight for your client without being passionate. The canons of ethics require the attorney to be zealous. It does not require the attorney to be passionate. And that's the problem. If there's one big problem here, is that this language is too often passionate when it really doesn't need to be. There's no need for this. Please stop. I'm asking, please. You seem to rapidly go to the most negative space possible. I know I'm making this. I don't know how else to say this, but I'm trying to help, man. Please stop doing this. Please stop making this so antagonistic. Why this is not helpful. So not you were suggesting. Much better. It could be read to suggest. By putting in a declaration, you were suggesting there's a conflict with me, proceeding to represent Katie and without a crystal ball. I can't proceed with the threat hanging over my head that you'll move to disqualify me. This is language that's unnecessary. You are implying the other side is threatening you. You're implying the malice there when you don't have to. I understand completely why you think that there's this sort of Damocles. I understand why you think there's this sort of Damocles hanging over you. I get it. I really do. I understand why you think that's a possibility. But we don't need to do it this way. You don't need to say it's a threat. You just need to you need to rework. You need to work on the language, man. It's not helpful. It's not helpful. You clearly indicate on your call that you have no intent to do that. I understand that if you commit to that in writing, I will not need to bother the motion to qualify. How do you think the other attorney is going to respond to this? This is baiting. This is baiting. And I don't think, let me rephrase. When I say this is baiting, that could be understood to imply that I think Brown is purposefully baiting. I don't know if that's true, and I kind of hope it's not. So maybe this is intentional. Maybe he's doing it on purpose to wrangle up the other side. Maybe this is all part of some grand litigation strategy. One can only hope. Maybe Michael Brown just has a different idea about how to be a lawyer or be a lawyer in this case. And that's fine. That's fine. You know, maybe he has some strategy or some tactic here that I'm just not seeing and not appreciating. And maybe Brown is a better lawyer than me, which is definitely a strong possibility. He's had more experience than me in the relevant domains, so maybe he's a better lawyer than me. And maybe he has a strategy here that I'm not getting. And maybe he is being purposefully antagonistic for some reason that he thinks will serve his case. I don't see it, but okay. Maybe that's a possibility. Or maybe this is a personality issue of Brown and he doesn't realize that he's doing it. Maybe he doesn't realize how this is being read. Maybe he's blind to the possibility. If that's true, Michael Brown, seriously, your language can be read as being very aggressive. If you were not aware of that, let me tell you, as someone who is trying very, very, very hard to be as neutral in this case as possible and trying to give every side their due, I find your language to be aggressive in ways that are not required by the situation. So, if you didn't know that, I'm here to tell you, this is not helpful. You don't need to run to the end of the page. You don't need to assume the worst every time. Everything you're saying is plausible, but it's the worst possible interpretation of reality. Maybe don't slam the door in the other counsel's face and make them drive them to the end of the page. If you're trying to do it for some reason, I guess. I don't know what that is, and I'm not sure it's professional, but I'm willing to hear an argument on it. So if you're trying to do this deliberately, then I guess mission accomplished. But if you're not trying to do this deliberately, and you're not aware that you're doing this, and it's making me sad. From Jeffrey Bianco, I think it's important to distinguish between Ms. Barnhart says in her declaration and what I've said. I don't think you can attribute statements made in her declaration to me or any lawyers for plaintiffs in this case. Okay. That being said, I don't know what relationship actually existed, if any. So ask me to stipulate to the existence or non-existence of a relationship you may or may not have with a third party seems to put me in a tough spot, which is perfectly understandable. I don't know if this is an issue or not, and I don't want to waive my right to raise this as an issue if and when I learn more, which is reasonable. Which is why I said a stipulation from me for now may be worth anything, because I want to reserve my right to change my mind if and when more information becomes available. You know, this is a perfectly cogent response. A perfectly understandable response. He doesn't know what he doesn't know, and he's willing to admit that he doesn't know what he doesn't know. So you're asking me to stipulate something when I don't know. And that's putting me in a tough spot. Fair. Thanks, Jeff. What I want is simply a stipulation reflecting what Michael said on the call. You have no current concerns that would cause you to ask for disqualification. I'm not asking you to waive any argument that might arise based on information you discover in the future, although I cannot imagine what that would be. Which I can't imagine what that would be either, but, fair enough. I've revised the draft stipulation to clarify. Please let me know if this is acceptable. This is much better from Brown. This is better. So, better. Michael, that's not my recollection of what we said during the call. Fair enough, which is, again, why you want to have these emails in writing, so you can understand what is and is not said. That's the point of these. So, good job on the point of it, not so great on the execution of it. The purpose of this is to put the letter in the file and make sure that we're all clear so we don't have to have a dispute later. But not so great on the execution related to that. My recollection is what we represented was that we didn't intend at the time to make a motion on the court. I do have concerns about this issue. The scope and parameter of any relationship or lack thereof you may have created with Barnhart during communications with her is not something I'm prepared to stipulate to. Fair enough. Nor I think a stipulation to not raise this issue now while I reserve my rights is of much use. That's probably true. That would make him feel marginally better, so I guess. I'm not sure what the motion is you intend to bring before the court. Is your intention to ask the court to make a finding of fact that you were never in an attorney-client relationship between you and Barnhart? That does seem to be kind of what's going on. If so, I don't believe I've ever seen such a report in this context. Neither have I. I also think my stipulation would have any bearing on that determination. Fair enough. So, yeah, okay. So, yeah. This is like, yeah. Not the best lawyering I've ever seen in my life. Question, what would this have cost KJ? Do you mean this specific motion or this entire case? If you mean this specific motion, I don't know. Let's say $1,000. If you mean this entire case, way too much. I think we're $100,000. Yeah. Brown seems to be emotional or something in a way that's not particularly helpful. Yeah. So I think other than the motion to dismiss, Brown has been a good attorney in substance, but I think some of his language and some of his positions are extreme if plausible. So I think Brown is a competent attorney, but I first of all, that motion to dismiss was a train wreck, so I don't know who wrote that, and I hopefully not Brown, and probably not, given how good it's been after that. So there was that. But other than that, the language and always going to the most extreme, it's like a person who suffers. I mean, I don't know how to say this more kindly. It's like, and I'm not saying this is true, so make that claim plain. I'm not saying this is true. But it's like a person who suffers from paranoia. Like everything that they think is kind of a plausible interpretation of reality. It's just a very negative, and it's always the most negative interpretation. So, it kind of makes me sad. It's like talking to a moody teenager. Kind of, sort of, yeah. Brown knows Katie can't pay him. I don't know how Brown is getting paid. For what filings cost, KJ could have bought a house in Washington? Maybe. If everything after reply was filed with leave of the court, but they never gave permission, because she ruled nothing after is admissible. The motion for the SIR reply was filed with leave of the court, not everything after. That being said, however, the court can still ignore everything. Because the issue is personal jurisdiction at the moment. And none of this matters. It doesn't even matter to the motion to dismiss for lack of failure to state a claim. All this is irrelevant. All of it is irrelevant. The judge can ignore all of it. The judge can ignore all of it. And if I were the judge in this case, I'd be ignoring all of it because none of it matters. It doesn't matter. And if I cared at any point, I long since stopped caring. On a motion to dismiss, the pleading and the attachments thereto have to be accepted as true as to any disputed fact. Not as to law, but any disputed fact. So the only thing I care about for the entire motion to dismiss, not just the jurisdiction issue, the entire motion to dismiss, the only thing I care about is the complaint and the attachments thereto. Right? And then I care about the legal arguments from Brown. I very much don't care about any facts from Brown for the purpose of the motion to dismiss, because that's the law. And so when Brown attached a declaration from Katie to the motion to dismiss, I was befuddled. Because why? All Katie can do is say these are not facts. But that's not how this works on any level. All the facts are what Tati says. What Tati says is true, unless it's palpably absurd. So you take the pleadings, and you take the attachments, and you take any facts that Tati says, and you're like, okay, everything there is true. Then you look at the law argument from Brown. Here's why, given everything as true, we still win. So the judge can quite reasonably ignore all this. I would, because none of this matters to the legal issue. Again, master circle, man. Antonio Banderas over here with Anthony Hopkins. Master circle. All that matters is what's in the circle. And all this stuff is not inside the circle. It's not even close to the circle, man. This is a square. This is a square. It's not even close to a circle. This is a square. So yeah, yeah. So the judge can, and in my humble opinion, should ignore pretty much everything that's been filed in this case, because basically none of it is relevant to the issues at hand. We had everything we needed on the motion to dismiss long ago. We had the motion to dismiss, we had the reply, we had the response, we had the reply, and then we had a request for a surreply. That's all we needed. We had everything we needed long ago. Long ago. And nothing else matters. And nothing else matters. Get some Metallica in here. Yeah. What other questions do you have? I don't know why the lighting's giving you good vibes. Thanks, man. I changed the color lighting. I think it's good. Good. I love that you're trying to help the situation by getting it back on the narrow path. Right. Everything I needed to know I learned in kindergarten. Or everything I needed to know I learned by the time we were done with the surreply. And then I'll go analyze the law and figure out what the law is. You know. I'd have to actually go read the cases and figure out what the law is. As one does when you're a judge. Right? You go read the law and see what it teaches. And then you do that. Are all these filings attached to the motion to dismiss? They're not. No, not really. They're kind of derivative of the motion to dismiss, sort of, kind of, but they don't. None of them matter. Are they attached to the motion to dismiss? No, but they're sort of somehow in the universe of that or something. But no. More malarkey, yeah. Is this something KJ has to pay for? Probably. How's your part of Texas right now? It's brutal. It's brutal. Fortunately, I've been in good condition. I have maintained power pretty much the entire time. So I've been lucky. I've been really, really lucky. Thank you. I'm right in downtown Austin. So I've been really, really fortunate. I've had power and heat and food and water the whole time, or, virtually. And it's been fantastic. And so I've been really, really lucky. But thank you for asking. And I thank whatever power there might be for this, because I've been seeing the news just as so many of you do, and people starving and hungry and without water, and their houses cold, and people are using camping lamps. People are using camping flames and grills to cook food indoors, which is understandable because they need food. But they're burning camping fires. They're like portable ones that, they're burning those like camping, I don't know what else you would call them. Camping cooking things. They're burning camping cooking things and grills indoors because they can't do it outdoors because it's freezing. It's literally frost warning, literally freeze warning. So they can't be outdoors. So they're using them indoors. Anyone know why that's a bad idea other than me? There's a lot of people who probably don't know why that's a bad idea other than me. So, yeah, that's good news. In case you're wondering and you don't know the answer to this question, the reason that this is a bad idea is carbon monoxide poisoning. So, yeah. Yeah. Yeah, carbon monoxide poisoning would be the answer to this question. Yeah. Check Yourself says there's no gas. Well, people might have gas themselves. They might have the portable bottles or, the propane bottles. So they might have gas. I mean, they might have some gas. So, but you're right. There's like no new gas coming in, but they might have bottles of it somewhere. As long as your stove doesn't have an orange flame, you're good. Yeah. Yeah. So basically, everyone's freezing to death. Everyone's starving to death. Everyone's dying of dehydration. It's bad. And we got a frost warning today. We got a frost warning today about, how there's going to be another cold snap with record low temperatures. So, good times. I have plenty of food, thank you. I'm fine. Yeah, I mean, yeah, there is a way to mitigate there is a way to mitigate the carbon monoxide. Of course, the way to mitigate the carbon monoxide is to open up a window, which when it's, 14 degrees outside with a strong wind presents its own problems. So basically it's all sucks. Anyways, Nathan Lore says, how can Brown ask for sanctions based on attorney-client relationship now? He wants the court to find no attorney relationship. He's not asking for sanctions exactly. He's just asking to make it clear that he didn't do anything wrong, which okay. Yeah. They definitely have propane heating systems in Texas. I learned that from King of the Hill, man. What are you talking about? King of the Hill taught me that there's propane in Texas. You guys are out of your mind. If there's other questions about the case or anything, I'll be happy to answer them. Brown asked for sanctions in the last motion. Yeah, not related to the attorney-client thing. He asked if related to something else for the Brown Hat declaration because they knew it was false. It doesn't require him to be an attorney for that motion, and the reason he can ask for it is because there's jurisdiction over the attorneys. He asked for sanctions after Jeff said he's not asking for sanctions in this. This is not a motion for sanctions. This is just a request to make sure that he can stay on as a lawyer. So this is not a request for sanctions. This is a request to make sure that he can still be a lawyer. Yeah, propane accessories. Yeah, that's right. I'm looking at houses in Texas. They all have electric stovetop, no gas. King of the Hill, man. Is Brown trying to get out of this case? Technically speaking, in this motion, he's trying to stay in it. So, yeah, I don't know, man. Yeah, Texas doesn't have weather like this. Next, you'll be wondering why we don't have snow tires. Pretty much, yeah. I lived through that in Colorado. A restaurant blew up and took an entire block. We didn't have gas and water for 4 days. It was in the middle of winter. What and where do you think we'll hear of next? I don't know. Later today, probably, while we're talking, because this case never dies. Brown said the Saul sanctioned last motion because Lorianne was his client. No, that wasn't. He didn't say because Lorianne was his client in the last motion, I don't believe, if I read it correctly. He didn't say because Lorianne was my client. He said because Saltz had a whole bunch of information from a time when I was talking to Lorianne, but I don't believe he actually said that Lorianne was his client in the last motion. He just said that Saltz did or should have known better from all the communications he had with Lorianne, but I don't believe he said that he was the client in the motion. I don't believe Nate. So, I mean, I don't have a perfect memory, but I don't believe that's true. I don't believe, yeah. Question, are you any closer to guessing when we'll get a decision on the motion dismissed? Not really, because this case never dies. It really should happen, I mean, soon, hopefully. Think you want this dismissed? Make it someone else's problem? I don't know what makes sense. If there is a pile of money out there, Brown is getting a pile of money, so that's nice. Makes me want to be a lawyer in this case because at least I get access to a big pile of money, so I got that going for me. If Brown got dismissed by the judge, who would pick up the work? If there's a big pile of money, I'll take it. I'm going to need the money up front, though. So there's that. I'm going to need a big pile of money up front, but I'll take the case. I'll do a better job, too. I'll take the case for KJ. KJ deserves good representation. And, I'm going to need a big pile of money up front, though. And I'll be like, yeah, we need to hit the reset button on this big time. Can we agree to mutually withdraw, like, all the motions for the last 30 motions? Can we mutually agree to strike, like, 30 things? That'd be great. And just let also, could I get another crack at that motion to dismiss? That'd be really nice. Can I get another crack at that motion to dismiss? They'll say no to that, but I can at least ask. If I was judge, what would I do at this point? I'd file a minute order saying you can't file new stuff. That'd be what I'd do as judge. There'd be a minute order saying you're not allowed to file anything. And then I would do the motion to dismiss and decide jurisdiction. And if you're asking me what I do on jurisdiction, I don't know, because I don't know the law that well. Right? That's a fairly specific question that I don't have the answer to off the top of my head. I know the general parameters. We've read the general case law sort of peripherally, but we have not read it in the level of detail that I would need to decide the issue. So I'd have to go read the law. But I definitely put in a minute order saying you can't file anything else. That would definitely be a thing that would happen. Nate says, is a clear violation of Rule 4.2 require them to do the moment she told them she's represented by the undersigned? Maybe. Yeah, that's fair. That's fair. Maybe. It's not clear. It's not clear that she told them that. It's not clear. I mean, a whole bunch of things are not clear. Yeah, I'm surprised to hear there's another motion. Brown has drunk or has a drug problem? I don't know. Saltz is a good lawyer. It would be an honor to try to go onto the battlefield and try to compete against Saltz, because Saltz is a really good lawyer. But I like to think I can hold my own, kind of, sort of. So, if Katie needs new counsel, and she has a big pile of money setting aside that she can give me for a retainer, I am looking for a new job, incidentally. I don't like my day job anymore. I'm tired. So maybe this could be my break into a different world. This could be my break into a different world. That's good. Yeah. So yeah, I'll quit my job. I'll quit my job. Serious. I'll quit my job and I'll do this. Because this would be more fun. And then I'm gonna have a conversation with Salts and take him out for some sushi. I'll take Salts and his team out for sushi and a round of drinks. That'll be the first way I'm spending the client's money, because we need to mend some bridges. So I'm taking Salts' entire team out for some sushi, or maybe some hibachi. Hibachi's good. Hibachi's fun. I'll take his entire team out for some hibachi and some drinks and be like, let's start over. Let's start over. I'll concede jurisdiction if you give me another crack at the motion to dismiss, because I could really use it. You know? So there's that. Salts is a good lawyer and Brown charges $450. I wouldn't charge $450. So I'll charge a lot less. I'm discount. I don't have the credentials for $450 an hour, especially in this field of law. I'll do it for $200. Also, KJ has to stop making videos. That'd be great. Yeah, no, yeah. Take him out for some hibachi. Yeah, I'll do it for $200 an hour. I think Katie wrote that motion to dismiss, maybe. Yeah. Anything else? Don't sell yourself short, Kurt. I'm not practiced in this field of law. My field of law is patent law, which it's a specialized domain, and I know that. I'm not worth $450 an hour in this domain. I'm not. It will take me longer to do things than it would someone. The reason someone makes $450 an hour is because they can work faster, because they can do a lot more, because they don't have to do as much research, because they know everything off the top of their head, and I'd have to do more research. So, I'm reasonably worth $200 an hour in this domain. Plus expenses, of course. My state attorney charges $280. Yeah, but he's a specialist in the field. I'm not a specialist in this field. I'm a good attorney. I'm competent. I know how to run this case. So I can meet the rule for competence, but I don't have the experience. So I'd have to charge a relatively lower rate. So $200 an hour would be fair. Is it possible Swanson's funding the case? Yes, it's possible. I obviously don't know who's funding the case, but yes, it's possible. Yeah, she'd definitely save a lot of money on filing expenses alone. That'd be true. All right, well, there's no more questions, I guess, at the moment. In the unlikely event I become Katie Joy's lawyer, I guess, well, I have to stop doing these videos. I guess I'd have to think about that, because I'd be talking about the case. So I might have to stop doing the videos. I don't know. I'd have to think about it. But, yeah. Maybe Salts and I could do a joint video. That'd be good. If I became an attorney, maybe Salts and I could do a joint video. That'd be good. My special guest tonight is my opposing counsel, Michael Salts. How you doing, Michael? Good. So what do you think about this case? So forth and so on. That'd be an interesting conversation. That'd be an interesting one. I become Katie's lawyer. We have Michael Salts on as a guest, and we have a conversation. That'd be good. Hear from Emily? Yeah. There seems to be plenty of YouTube lawsuits. Oh, okay. Well, Spurgy, if there are other YouTube lawsuits, Uncivil always looks high, really. But anyways, if there are other YouTube lawsuits, just contact me on Discord and let me know, please. Just DM me. Just DM me the cases if they're YouTube lawsuits. I'd be very, very interested in covering all their Law 2 YouTubes. But you think I always look high? I'm not high, but yay. Yeah, I figured it was you. No way 2 people have such a unique game. Oh yeah, there were some super chats. I'm sorry. I had forgotten about those. That was my lack of indulgence there. Let's do some super chats before I sign off. $20 from News Now Wyoming. Could I do a legal analysis of Taylor versus Rojas and what you think it means to qualified immunity? I did a video analysis and said nothing more than hope and doesn't open any new doors. People are upset at the analysis. Sure, I'll look into that. Let me put it into my paid stories queue. Where is my paid stories queue? Because I always forget where it is. Okay. Taylor versus Rojas. You got it. Barnhart versus Thomas. US 2003. All right. Thank you for that. It's very appreciated. There was for $20 from Nate. That's very kind of you. Nato gave me $5 as well. Natasha gave me $5. I hope the judge admonishes Brown. This is just beyond reason. $5 from the dark side. Boomer Melissa. Considering if I've gotten out of hand with super chats this month and only for you, this is just cuz. Thank you, the dark side of Melissa, Boomer Melissa. And $5 from News Now Wyoming. The last $5 on my request to bring it to 25. Thank you. It's very kind of you. Yeah. Yeah, just message me on Discord with other YouTube lawsuits. I'm very interested in covering other ones. I'd appreciate it. She's attorney in the AG office. You recommend a lawsuit in Discord? Thanks. Just let me know where I can find it. I'm very interested in that. $9.99 from Angelica. Thank you very much for that super chat. There are any cases that fascinate you that like to cover in the channel? I'm very interested in stuff that will gain more engagement and more subscribers. So if there's more stuff on YouTube, I'd really like to see that. That'd be great. Cheryl's World filed a lawsuit? Yeah. Cheryl's World filed a lawsuit? Okay. Let's let me put I need to figure out a place to put this. Let me put it in help. Story suggestions. Cheryl's World. All right, I'll take a look at that. Thank you. What for you're interested in patent law? What for you interested in patent law? I don't know. Would I ever cover Betty Bodrock case from 1989? Maybe the opinion in it. Keemstar case? Okay. Okay, I'm going to sign off. If you're enjoying this content, please remember to like it. Please remember to subscribe if you've not done so already. Please hit the join button that Streamlabs is advising you about right now. You can click that link to become a member, help support the channel financially. Please contact me on Discord if you have cases that are good YouTube cases. I'd really, really appreciate it. Until later, cheers and bye.